Ladies and gentlemen, I deem it a great honor to be invited to give a talk on making India role of empowering citizens with legal awareness on the occasion of inauguration of Justice V.K. Krishna Iyer International Mission for Social Justice. I wish and hope that this will leave a mark as an important milestone in spreading the ideals and aspirations of the departed great jurist and usher our nation into a new era. I thank the organizers for giving me this opportunity. Para. Our Constitution provides for an effective and independent judicial system. Right to access to justice has been recognized as one of the fundamental rights. Justice delivered or administered by justice is one of the paramount functions of the state. We cannot be said to fulfill our social obligations unless we are able to promote justice on the basis of equal opportunity and provide legal aid to all citizens of the country. Para. To bring justice closer to the underprivileged segments of the society, a number of innovative measures, including providing legal aid to poor, have evolved with time. Article 39A of our Constitution provides that the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity and shall, in particular, provide free legal aid by suitable legislation or schemes or in other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. In a number of judgments, Supreme Court has also emphasized the necessity for providing legal aid to the poor. Para. The language of Article 39A is couched in mandatory terms. This is made more than clear by the use of the word shall occurring twice in Article 39A. It need not be emphasized that good legal system should be able to deliver justice expeditiously on the basis of equal opportunity and provide free legal aid to ensure that opportunities for securing justice are not denied to any citizen by reasons of economic or other disabilities. The Supreme Court has emphasized while interpreting Article 21 in the light of Article 39A that legal assistance to a poor or indigent accused who is arrested with jeopardy of his life or personal liberty is a constitutional imperative mandate not only by Article 39A but also by Articles 14 and 21. In the absence of legal assistance, injustice may result, and every act of injustice corrodes the foundations of democracy. Para. It was in this context that the Parliament enacted the Legal Service Authorities Act 1987. While on one side the act gives statutory recognition to the resolution of disputes by compromise and settlement by the Lok Adalats. On the other, it provides for free and competent legal services to the weaker sections of the society. The concept of Lok Adalat has been gathered from system of panchayats, which has root in the history and culture of this country, and the provisions of the act are meant to supplement the court system. You are aware that National Legal Services Authority was constituted in the year 1995 under Section 3 of the Legal Services Authorities Act 1987 para. Apart from making legal aid a constitutional right and extending its scope to legal literacy and pre-trial processes, the contribution of the judiciary in access jurisprudence lies in giving a status and credibility to public interest litigation unprecedented in the judicial history of the so-called developed countries of the world. You are aware of the developments where access has been enabled on matters involving public interest even to total strangers to the dispute, and the expanded doctrine of standi by which a civil rights organization has been allowed to maintain a petition for the rights of a class of the society. Another development facilitation the PIL is the acceptance of what are called letter petitions, where any citizen, without seeking the help of lawyers, can now activate the court by writing a letter, which the court treats as a writ petition in appropriate cases involving violations of fundamental rights. Para. The Constitution has made provision for promoting the aspirations and protecting the rights of different sections and classes of Indian people in addressing themselves to the delivery of justice. The courts must necessarily pay heed to the ideals and objectives enshrined in the Constitution and to the broad provisions made in relation to those sections and classes. Nevertheless, the court remains the guarantor of justice to all citizens in accordance with their respective rights and obligations. In assisting the courts in their great purpose, the legal profession holds a role of considerable significance. It is a role assigned to the legal profession by history and by the nature of its functions. In order to make our laws more effective, the bench and the bar must work together with an intuition to work for the objectives of our Constitution. Our Constitution is not to be constructed as a mere law but as the machinery by which laws are made. It is a living and organic thing which, of all instruments, has the greatest claim to be constructed broadly and liberally. Stop.